Breaking news. Mazi Nnamdi Kanu sentenced to set to overruled by appeal court as his foreign lawyer Ben Bruce Frame exposed Justice Omotosho. Hear the news in details. Alright, this is Star News 24. Kaisi minotoro nya bozi no bosinketa. Biko gere ya bozi dika hanuju. Kabakwaru kidara na kana comment ifiche no dinkege. Over to you, sir.
Today, I want to walk you through a developing legal and political situation that has captured significant attention across Nigeria, particularly concerning Nnamdi Kanu, the leader of the indigenous people of Biafra, and the serious legal challenges now being raised against his recent conviction. This is a story that touches on fundamental questions of legal procedure, judicial authority, and the very foundations of how justice is supposed to work in any democratic society. So, let me take you through this step by step, explaining not just what has happened, but why it matters and what the legal experts are saying about where this case is headed. As of today, Wednesday, December 3rd, 2025, it has been 13 days since Nnamdi Kanu was transferred to Sokoto State Prison following his conviction. Now, this transfer itself has generated quite a bit of buzz because Sokoto has essentially become something of a pilgrimage site for supporters, politicians, and observers who want to see Kanu and express their support. Among the most notable visitors has been Governor Alex Otti of Abia State, whose visit carries significant political weight. When a sitting governor makes the journey to visit someone in prison, especially someone as controversial and politically charged as Nnamdi Kanu, it sends a clear message about the level of political support and pressure surrounding this case. These visits are not just social calls. They represent a broader political movement and mounting pressure on the judicial system to carefully scrutinize what happened in the trial court. Now, let me explain the timeline that is critically important here. While Nnamdi Kanu technically has 90 days to perfect his appeal, which means to complete all the procedural requirements and documentation needed for the appellate court to fully consider his case, there is a much tighter deadline that creates urgency. He has only 14 days from the date of his sentencing to file and formally register the appeal with the Court of Appeal. This 14-day window is crucial because if it passes without the proper filing, he could lose the right to appeal altogether, regardless of how strong his legal arguments might be. According to the information available, December 4th represents the final deadline for completing this initial documentation, which means as I speak to you today, his legal team is working against the clock to ensure everything is properly filed. The political dimensions of this case cannot be overstated. According to various political commentators who have been following this situation closely, there are powerful individuals, often referred to collectively as a cabal, who are deeply concerned about Kanu's appeal moving forward. Why would they be worried? Well, the argument being made is that these individuals allegedly influenced both the location where Kanu was tried and the nature of the conviction he received. The fear, according to these observers, is that once the case reaches the Court of Appeal and is subjected to proper appellate scrutiny, the conviction will not survive because of fundamental legal defects in how the trial was conducted. In other words, there is a belief among many analysts that the trial court judgment was so flawed that it cannot withstand the rigorous examination that an appellate court would apply. This brings us to the heart of the matter, which is the legal analysis conducted by the Mazi Nnamdi Kanu Global Defense Consortium. This is not just a local legal team. We are talking about an international group of lawyers with expertise in comparative law, constitutional law, and criminal procedure, reportedly based in the United States and the United Kingdom. These legal experts have undertaken what they describe as an extensive review of the trial record, examining every aspect of the proceedings, the charges, the legal framework applied, and the judgment itself. Their conclusion is stark and unequivocal. They have determined that Nnamdi Kanu's conviction cannot and will not stand at the appellate level due to what they characterize as major, fundamental legal defects that go to the very jurisdiction of the trial court. Let me break down their central argument because it is both technical and absolutely critical to understanding why this appeal is being treated as virtually certain to succeed. The defense consortium has identified what they believe is a fatal flaw in the trial.
They claim that Justice Omotosho, the judge who presided over the case and handed down the conviction, relied on a law that had been repealed. Specifically, they say he used something called the TPA 2013, which stands for the Terrorism Prevention Act of 2013. However, by the time Nnamdi Kanu was being tried, this law was no longer operative. It had been replaced by a newer statute, the TPPA 2022, which stands for the Terrorism Prevention and Prohibition Act of 2022. Now, you might be wondering why this matters so much. After all, these are both terrorism-related laws, so what difference does it make which version the judge used? Well, in legal terms, this difference is everything. It is the difference between a valid conviction and what lawyers call a nullity, meaning something that is void from the beginning and has no legal effect whatsoever. Let me explain the principle at work here. When a legislature repeals a law and replaces it with a new one, the old law does not just become outdated or less preferred. According to well-established legal doctrine, a repealed law becomes legally extinct. It ceases to exist for legal purposes. It is as if that law was never written, at least from the moment of its repeal forward. This is not a minor technical point. It is a foundational principle of how legal systems operate. The defense team has pointed to multiple Supreme Court precedents that establish this principle beyond any doubt. They specifically reference two landmark cases. The first is Attorney General of Lagos State vs. Dosumu, decided in 1989. The second is a case called Waifu versus the Attorney General of Bendel State. Both of these Supreme Court decisions established a clear rule that when a court applies a repealed law as the basis for criminal charges or a trial, that court lacks jurisdiction. And when a court lacks jurisdiction, nothing it does has legal validity. The trial is considered a nullity. The conviction is void. It is as if the proceedings never properly occurred in the eyes of the law. The defense consortium has emphasized that this is not a situation where there is some ambiguity or where reasonable people might disagree about which law applies. They argue that this is black and white. When a law is repealed without a saving clause, which is a specific provision that allows the old law to continue applying to cases that were already in progress, then any attempt to use that repealed law is simply without legal foundation. They stress that Section 97 of the 2022 TPPA actually addresses this very issue. According to their reading, this section requires that pending charges must migrate to the new law. In other words, if someone was charged under the old TPA 2013, but the case had not been completed when the new TPPA 2022 came into effect, the charges must be reformulated and brought under the new law for the trial to proceed validly. The defense team has also revealed something quite telling about what happened during the trial itself. They say that Nnamdi Kanu, representing himself at various points or questioning the proceedings, repeatedly challenged Justice Omotosho to show him the law under which he was being tried. This was not just a rhetorical question or a delaying tactic. Kanu was making a fundamental point. He was essentially saying, you are trying me under a law that no longer exists. Show me the current valid law that gives you the authority to do this. According to the defense consortium, the judge could not provide a satisfactory answer to this challenge because there was no satisfactory answer. The law being applied was no longer on the books. To help people understand just how serious this is, the defense team has drawn a comparison that really drives the point home. They said that what Justice Omotosho did is comparable to trying to convict someone today using colonial-era laws from before Nigerian independence or using laws from the military dictatorship periods that have long since been repealed. We all understand intuitively that you cannot put someone on trial in 2025 using a law from 1960 that has been repealed. You cannot resurrect dead legislation just because it is convenient or because it might make a conviction easier to obtain. The same principle applies here. The TPA 2013, according to this argument, is just as dead in legal terms as any colonial-era statute, and attempting to use it renders everything that follows legally invalid. This is why the defense consortium insists that the entire trial is a nullity.
They are not saying the trial had some flaws or made some mistakes that need to be corrected. They are saying the trial lacked jurisdiction from the very beginning, from the moment the first charge was read under a repealed law. When a court lacks jurisdiction, it has no authority to proceed, no authority to hear evidence, no authority to render a verdict, and no authority to impose a sentence. Everything that happened is, in legal terminology, void ab initio, which is Latin for void from the beginning. The political analysts who have been commenting on this case have reached a remarkably unified conclusion. They believe that when this appeal reaches the Court of Appeal, the appellate judges will have no choice but to strike out the conviction. This is not presented as a matter of opinion or political preference. They are saying that the law is so clear on this point that the Court of Appeal, if it follows established legal principles and Supreme Court precedent, must find that the conviction cannot stand. This is why, according to these commentators, there are powerful forces trying to prevent the appeal from going forward or trying to create obstacles to delay it. The fear is not that the appeal might fail. The fear, from the perspective of those who supported the conviction, is that the appeal will succeed precisely because the legal foundation of the conviction is so weak. What we are witnessing here is a convergence of law and politics in a way that is both fascinating and deeply troubling. On one hand, we have what appears to be a straightforward application of legal principles that any first-year law student would recognize. A court cannot apply a repealed law. Jurisdiction is fundamental. Without jurisdiction, a conviction is void. These are not controversial propositions in legal theory. They are basic, foundational principles that protect everyone's rights and ensure that the legal system operates according to established rules rather than arbitrary power. On the other hand, we have the political reality that Nnamdi Kanu is not just any defendant. He is a highly controversial figure who leads a separatist movement that has challenged the Nigerian state in fundamental ways. His prosecution has always been as much about politics as about law. The decision to try him, the charges brought against him, the way the trial was conducted, and now the attempts to either support or obstruct his appeal, all of this takes place in a highly charged political environment where different factions have different interests in the outcome. What makes this situation particularly significant is that it raises questions about the independence and integrity of the judicial system. If the defense consortium is correct in their legal analysis, and if the trial court really did apply a repealed law in violation of clear Supreme Court precedent, then we have to ask how this happened. Was it an honest mistake by a judge who somehow overlooked the fact that the law he was applying had been repealed? That seems difficult to believe for a judge at the Federal High Court level. Or was there pressure, either implicit or explicit, to obtain a conviction regardless of the legal niceties? And if there was such pressure, what does that tell us about the state of judicial independence in politically sensitive cases? The involvement of international lawyers in the defense consortium is also significant. These are legal experts who are not embedded in the Nigerian political system, who do not have personal stakes in local political conflicts, and who are evaluating the case from the perspective of international legal standards and comparative jurisprudence. When such experts reach a unanimous conclusion that a conviction is legally unsound, it carries particular weight. It suggests that this is not just a matter of local political dispute, but a case where fundamental legal principles recognized across common law jurisdictions have been violated. As we approach the December 4th deadline for filing the appeal, the tension and attention surrounding this case will only intensify. The question now is not whether the appeal will be filed, since Kanu's legal team is clearly committed to pursuing it, but rather how the Court of Appeal will respond when it is faced with these arguments. Will the appellate judges carefully examine the question of which law was properly applicable? Will they follow the Supreme Court precedents that say a repealed law cannot serve as the basis for a valid conviction?
Will they have the independence and courage to overturn a politically charged conviction if the legal analysis demands it? The broader implications of this case extend far beyond Nnamdi Kanu himself. If a conviction can stand even when it is based on a repealed law, then none of us are truly protected by the rule of law. If courts can ignore Supreme Court precedents and basic principles of jurisdiction when the case is politically sensitive, then the law becomes merely an instrument of power rather than a protection for rights. This is why legal experts and civil society observers are watching this case so closely. The outcome will tell us something important about the state of the Nigerian legal system and its ability to maintain fundamental standards of justice even when the political pressure is intense. Nnamdi Kanu's case has laid bare the profound dysfunction and moral bankruptcy that characterizes the Bola Ahmed Tinubu administration and the broader Nigerian state apparatus. What we are witnessing is not merely a legal error or procedural oversight, but rather a systemic assault on the rule of law orchestrated by a government more interested in political persecution than justice. President Tinubu, who campaigned on promises of national unity and constitutional governance, has instead presided over what can only be described as judicial lawlessness, where courts are weaponized to eliminate political opponents and silence dissenting voices. The Nigerian judiciary, which should serve as the last bulwark against tyranny and executive overreach, has instead become complicit in this charade. When a federal high court judge applies a repealed law to secure a conviction, this is not incompetence but complicity. Justice Omotosho's reliance on the extinct TPA 2013 despite the operative TPPA 2022 represents either staggering judicial ignorance or deliberate manipulation, neither of which inspires confidence in the integrity of Nigerian courts. The judiciary has abandoned its constitutional duty to serve as an independent arbiter and has instead become a rubber stamp for executive persecution, sacrificing its credibility and the fundamental rights of citizens on the altar of political expediency. The Tinubu government's handling of this case exposes the hollowness of its democratic pretensions. Rather than allowing the legal process to unfold according to established principles, powerful forces within the administration have allegedly interfered with where Kanu was tried, the charges brought against him, and now attempt to obstruct his appeal. This is the behavior of an authoritarian regime terrified of scrutiny, not a democratic government confident in the legitimacy of its actions. The so-called cabal that reportedly influenced these proceedings operates with impunity, demonstrating that Nigeria under Tinubu remains a country where power trumps law and political connections matter more than constitutional rights. The Nigerian military and security forces have been equally complicit in this travesty. Kanu's extraordinary rendition from Kenya, his detention conditions, and the entire security apparatus mobilized to prosecute this case reveal an institution more focused on suppressing dissent than protecting citizens. These forces, which should be defending the nation and upholding constitutional order, have instead become instruments of political repression, deployed to intimidate, silence, and eliminate those who challenge the government's narrative or authority. What is perhaps most damning is that it took an international consortium of foreign lawyers to expose the fundamental legal defects in this conviction. Nigerian legal institutions supposedly trained in constitutional law and procedure either failed to identify or deliberately ignored these glaring violations. This speaks to a systemic rot where professional integrity has been eroded, where fear and patronage dictate judicial outcomes, and where the entire legal establishment has abandoned its duty to justice. The Tinubu administration will ultimately be judged not by its rhetoric but by cases like this one, where the mask slips and we see the authoritarian impulses beneath the democratic facade. A government and judiciary willing to convict a man under non-existing laws have forfeited any claim to legitimacy or moral authority. Nnamdi Kanu's case represents an unambiguous indictment of the Bola Ahmed Tinubu administration and exposes the authoritarian rot consuming Nigeria's institutions. President Tinubu, who postured as a democratic reformer, has instead overseen a government that weaponizes the judiciary to persecute political opponents,
through blatantly illegal means. When a federal high court convicts a man using a repealed law, this is not judicial error, but state-sponsored persecution with executive blessing. The Nigerian judiciary has abandoned any pretense of independence or integrity. Justice Omotosho's application of the extinct TCPA 2013 represents either catastrophic incompetence or deliberate complicity in a political prosecution. Either way, it confirms that Nigerian courts have become mere instruments of executive power rather than guardians of constitutional rights. The entire judicial establishment stands accused of sacrificing the rule of law for political convenience. The military and security forces are equally culpable. From Kanu's illegal rendition from Kenya to his imprisonment in Sokoto, the security apparatus has functioned as an instrument of political repression rather than constitutional protection. These institutions, corrupted by power and impunity, serve the government's political interests instead of defending citizens' rights. Most damning is that foreign lawyers had to expose these fundamental violations, while Nigeria's own legal professionals either failed to notice or deliberately ignored them. This reveals systemic moral bankruptcy, where fear, patronage, and political calculation have replaced professional integrity and respect for law.
Ndị ba ngwadalụ dị nene dịka nsi wee na-esoro anyị n'ibe akwụkwọ na Eastern News 24. Unu anụgo na ife a bụ eziokwu a na-akụlọ mmiri bụ ya bụ ife wetara unu ụbọchị nketa. Biko ọ ya amasị m ka onye ọbụla gere ya bụ ihe react ya n'ihe ndị a anyị wetara unu ụbọchị nketa. Biko ọ bụla igere ihe a discript anyị tinyere unu, biko react ya to it. Ọ dị very important. Ngwa nke emesịa na ụmụnne m.